續返嚟嗰個會議嚇。
The meeting now resumes. Let's continue with paper CB brackets 1054 2025-03. That's the administration's reply to the submission by the Law Society of Hong Kong. Mr. Lee, please continue. Thank you. Just now we were talking about the arrangement for inspection of the register. Now there are some further views from the Law Society to which we will reply later on. Now paragraph 11 about the priority of registered matters. Under the LTO, the priority of registered matters is subject to Section 35. Now the Law Society's view is in relation to the charge, registered charge and the registered interest. Now there is a registered charge and then there is a consent caution and then there is the registration of the disposition. Then A, whether the registry will allow registration of the charging order if the substantial benefits interest in the property has already passed to the purchaser. Our answer is yes, because the register of charge will not affect the registration of other matters. Now B, if the scenario set out before is changed to that the charging order is registered before the CC. So that means there is first a transaction and then there is a court order and then there is a registered charge and then the consent caution. Then in the Law Society's opinion, the beneficial interest of the landlord has been transferred to the buyer. So it would seem that the charging order should have priority over the SPA. So in our reply, when the beneficial interest has been transferred to the buyer, whether the charging order is still valid would be subject to the common law principles, and we don't intend to regulate or change the order of priority. So the priority of charging order and the SPA will still be determined according to common law principles. Now C to D, in the scenario above, does the purchaser need to pay off the charge created by the charging order from the balance of the purchase price? And when a charging order absolute has been granted by court and registered, will the answer be different? So on the assumption that the consent caution is registered before the registration of the charging order, then according to Section 35, the priority of the charging order will be postponed to after the transfer related to the consent consumption. That's the so-called deferred validity, and the purchaser will take the property free from the charging order. And whether the charge created by the charging order will be paid off from the balance of the purchase price, it will remain to be governed by common law. So there are some further views submitted by the Law Society to which we will reply later on. Just a moment, Mr. Lee. Now, according to the latest letter sent by the Law Society, according to 11.4b, there are some questions. So may I invite Mr. Lee to give further response to the question. Now, the charging order is very common in Hong Kong. So please give us a reply in detail concerning that point. Thank you. Paragraph 11.5 in the submission about the time gap. On the date of application for registration, during the period after the date of assignment but before the date of application for registration, if there is a claim brought against the vendor, it will not be ideal because the previous owner is still the owner on the register. If there are any incidents during the period, then the original owner will have to bear responsibility. Now, under the current lease registration system, the purchaser will become the beneficial owner upon signing of the purchase agreement and has the title to the property upon execution of the assignment. Under the amended LTO, the purchaser will also become the beneficial owner after the signing of the agreement, and they will become the registered owner in the title registered upon registration of the transfer with the land registry. Mr. Lee, have you finished? Not yet. Since the effective date of registration of transfer is regarded as the date of lodgement of application, the purchaser is regarded to have been the registered owner from the date of lodgement application. Then during this period, the beneficial owner is subject to rights and liabilities under the common law. So, Mr. Lee, for anything that happens in the interim period, that is the gap, both parties will be governed by common law. Yes. There are no further questions from the Law Society concerning the issue of time gap. Now, the purchaser has no control over the length of the time gap, so some suggestions were made by the Law Society. We will reply to the suggestions later. Paragraph 12, statutory charge of stamp duty. Now, the Law Society does not have any views concerning the provisions, but there is one term which the Law Society finds it unclear, so we will propose an amendment to clarify the matter. And there are no further comments on that from the Law Society. Paragraph 13. In relation to Section 35 of the CPO, implied covenants for title. Now, the implied covenants can be expanded or amended according to the law. But our position is no registration is needed for the change. Now, there is the question whether the change needs to be mentioned in the specified transfer form, and the answer is yes. Now, if there is subsequent disposition of the registered interest on the form or instrument, how a third party may note that any covenants previously given in respect of the registered interest is affected by the exclusion, variation, or extension. Now, our position is that in the event that any exclusion, variation, or extension of the implied covenants is effected, then this information will still be available for search.
Mr. Andrew Lam has a question. My question is on implied covenants. Is it the basic assumption that it is aligned with the relevant and incidental implied covenants in the new land? Now, I give you an extreme example. For the small house land newly granted in the new territories, this is a common scenario. It's a newly granted land, so of course it's covered by the new LTO. But when it comes to the use of or right of way, because there is no right of way for some lots, implied covenants are needed. So coming back to the point here, thus the implied covenant relates only to new land, and that other covenants included in the transaction process will not be included. Now the implied covenants relate to the covenants agreed to between two parties. Now let me give you an example. The buyer may agree to an implied covenant that the buyer will abide by, for example, the deeds of mutual covenant and other relevant covenants after the buyer becomes the landlord. So that means in the assignment of the title, I have not breached any DMCs or any other covenants. I've paid the premium and the government rent, for example. These are covenants entered into between the seller and the buyer, and that it has nothing to do with, say, the right of way that you mentioned. Please continue. Paragraph 13.3 of the Law Society submission. This relates to overriding interest. Section 46.2 of the bill seeks to register the overriding interest in the title register so that subsequent purchasers will have knowledge of the same. And then paragraph 13.4, the Law Society asks this question about the first register or the overriding interest in the first transfer. How detailed should the reference go? Will general descriptions like covenants which run with the land as contained in the DMC of XX be accepted? Our response is that the first vendor or the developer should be able to ascertain and provide the purchaser with particulars of the overriding interest. For example, rights under the government lease may be ascertained by reading the government lease. Easements may be ascertained by on-site inspection. For example, whether there is any encroachment. So the first vendor should be able to provide such details to the purchaser. As for other rights enshrined in the statute law, such as an electricity supply line crossing the land, likewise, on-site inspection will allow the parties concerned to ascertain these rights, so there should not be difficulties in providing this information to purchasers. As for general descriptions such as DMCs and the relevant government lease, we believe these should be sufficient for the purpose of compliance with the disclosure requirement. We will engage stakeholders and Law Society on the future operational arrangement. We will also draw up guidelines on the disclosure requirements as well as the application form, etc. I have a question for Mr. Lee. For these rights of a special nature, is it necessary to include them in the transfer form? Your answer was in the affirmative. Now, the Law Society's point is to ensure certainty. Can you confirm, or would you ask lawyers to confirm whether such rights exist? We won't ask for the non-existence of these rights to be ascertained, but then if there are such rights concerned, you need to spell them out. The Law Society has given further views. We will give a response later. Paragraph 14 refers to transmission. Transmission registration refers to the court's order being granted and the interest of a party being passed on to another party. So, as per paragraph 14.3, the Law Society asks when the transmission should arise and what is defined by the time of transmission, as well as disposition. According to our reply, a transmission is effective at the time of transmission and not at the time of, for example, somebody passing away. As for disposition, it refers to the interest of an owner being passed on to another party. It happens not because of a court order. No further views have been received from Law Society. Paragraph 15 about disposition by personal representatives and trustees in bankruptcy. The original provision reads that if a transmission takes place, then disposition can take place if the personal representative and the trustee in bankruptcy is involved, provided that title can be proved. The Law Society believes this provision is not clear enough because the title register does not show the transmission of the personal representative, but only the disposition. And it should be made clear that the agent is acting on behalf of the landlord, and we will move an amendment to state that the personal representative will need to register the transmission before disposition. The same applies to trustee in bankruptcy. Paragraph 16 refers to trusts. According to the Law Society, and a bona fide purchaser who paid in consideration in value for the property acquired will be given protection, including 69(4), and that the trustee will be deemed to have all the rights of the beneficial owner. The same provision applies to 66(1) and 67(a)(1) in relation to the transaction being handled by a trustee in bankruptcy. Now, the Law Society's point is that usually for the so-called bona fide purchaser without notice, such an expression will be used, but there is no reference to without knowledge here. Law Society's question is whether it means there is no need to check the trust documents, or is it the case that this purchaser will still be protected even if the above has been breached. On the other hand, will the lawyer of the vendor but still be obliged to check the trust documents to ascertain whether the trustee has the right to sell the property? Our response is that the amended LTO seeks to provide title certainty for the bona fide purchaser who has provided valuable consideration. It is not required for a bona fide purchaser to be without notice of any irregularities in trust document which might render the title of the vendor invalid. That means there is no knowledge requirement. As long as this purchaser acts in bona fide and provided valuable consideration for the acquisition of the property, that will do. For bona fide, it means the purchaser is not acting in collusion with the trustee in order to deprive the person setting up the trust of the interest. As for the legal representative of the vendor, Under the common law, this lawyer is still subject to the common law standard of duty of care, that is, to exercise due diligence and reasonable care. There is no obligation to check the trust document to see whether the trustee has the right. Well, that means there is no exemption of this duty. On the contrary, that means the trust document will need to be gone through to see if this trustee has the right to do so. Mr. Andrew Lam. Thank you. I've read the document and I've just heard Mr. Lee's explanation, and I think I understand what it means about the knowledge requirement. Now, from the paper, and let me read out the following. It is not a requirement for a bona fide purchaser to be without notice of any irregularities in trust documents which may render the title of the vendor invalid. So in English, it reads without notice. I want to know in what circumstances would such a scenario arise. For example, there is a lack of duty of care or not. Well, let me elaborate on our legislative intent. Under the current deed registration system, the purchaser is required to check the deeds, and if a trustee is acting on behalf of the vendor, then there's also a need to check the trust document, because the trustee acts on behalf of the vendor in assigning the property. And if there is no authority for the trustee to sell the property, then in the end, the transaction is invalid. For a bona fide purchaser who has provided valuable consideration, our view is that the bona fide purchaser should not be footing the bill, so to speak, because of a breach of trust on the part of that trustee. So if our provision requires the purchaser to check the trust documents as well, it will be reverting to the current situation of checking deeds. The original intent of the LTO is for the title register to have the ultimate authority, and that there is no need to check any other background document. What we want to achieve is that a bona fide purchaser who has provided valuable consideration will be given legal protection. There is no other strings attached, such as with or without notice. And in English, we've put down irregularities, knowledge about or notice about irregularities. There is no need for the bona fide purchaser to verify whether irregularities have arisen before being given protection. Our intention is to go by the title register for the bona fide purchaser to verify the position. There is no need to revert to the old practice of checking deeds.
唔該晒。
Thank you. Next, Mr. Ambrose Lam. I understand what Mr. Lee is talking about, but it seems that there are some confusions concerning the term bona fide. Even if the purchaser is bona fide, if they are aware of some irregularities, they are still regarded as bona fide. That seems problematic. So the term is bona fide without notice. We are skipping the second part, that is without notice. We don't require the bona fide purchaser to be without notice. But what if there are evidence in the future proving that it is with notice, but still the purchaser is still bona fide? Bona fide refers to the action of purchasing. The only intent is to purchase the property with money. There are no ulterior motives in concert with the trustee. So I think it is very confusing to consider someone bona fide, even if they are aware of irregularities. We may have to, it may require some adapting, but the intent is to relieve the buyer of the duty to check all the past deeds. Now, what if I deliberately turn a blind eye on the irregularities? Will I still be considered bona fide? In my opinion, if I purchase a property, even with the knowledge of irregularities, then I would not be a bona fide purchaser. But there may be some parties with ulterior motives who deliberately alert the buyer to some potential issues that may stop the deal. Well, allow me to interrupt. I think under the new regime, the government must strike a balance. But I also understand the concerns raised by Mr. Ambrose Lam. May I invite Mr. Lee to refer to paragraph 24 of the latest submission made by the Law Society. I think if a purchaser has dishonest intent, they should be excluded from the definition of bona fide purchaser. Next, Mr. Louis Leung. Thank you, Chair. Now, first of all, I'm not a lawyer. But I also have issues with the term bona fide purchaser. There are established definitions in the common law system, but as a layman, if I'm a purchaser who is splashing out money on the property, then I should be regarded as bona fide. And also there is the term someone providing valuable consideration. So that means I'm using my money to buy a property. Now, from the perspective of a layman, is there a definition for the term valuable consideration? Say, for example, say the market value of a property is $10 million. Now, the agent told me I can purchase it with $6 million. Of course, I would be tempted. I'm willing to spend $6 million to buy a property, the market value of which is $10 million. But there is a significant difference between the actual transaction price and the market value. Will that disqualify me as being a bona fide purchaser spending valuable consideration on the property? Now, valuable consideration is opposite to nominal consideration, but there is no clear line between the two concepts. If a $10 million property is sold at $8 million, now that is undervalued, but the $8 million is still a valuable consideration. So $10 can be set as a nominal consideration for the property, but where should we draw the line? I think only the court can make a ruling according to the facts of the case. Well, I'm reassured by the answer. Of course, we will not be held accountable just by the mere facts. The court will make a judgment. So no matter how far the transaction price falls short of the market value, it can still be considered a valuable consideration. That's the policy intent. Next, Mr. Andrew Lam. I thank the chair for clarifying my question for me. The policy intent is to truncate the cumbersome process of these checking, but that must naturally create room for abuse. So the point is we have to draft the law clearly. If there are indeed conspiracies between the parties, I think the legal representatives of the vendor has the responsibility to provide all the relevant information. Sufficient safeguards must be put in place. I thank the chair because you refer the government to the latest submission from the Law Society. Any reply from Mr. Lee? Now, may I ask you a question as well? Regarding Section 66, you briefly mentioned about the inspection of deeds under the existing system. Now, the Law Society asked a question. I would like to seek a brief reply from Mr. Lee as well. Now, under the existing regime, the deeds inspection is in accordance with Section 13 and 14A of the Conveyancing Ordinance. Now, under the new regime, the land register will be the golden standard, but there are also implied covenants and other rights. So what should be the standard? Now, the documents required from the vendor is referred to in Section 36. Now, we expect that to include copies of existing deeds, but we will specify them in the subsidiary legislation rather than the principal ordinance to maintain some flexibilities. So under the subsidiary legislation, there will be some requirements like those in the CPO. That's better because without that, it would be quite risky. So let's continue. Paragraph 17 of the submission about the consent cautions. Now, Section 73, bracket 3, about the removal of consent cautions. Now, the provision is set out in paragraphs A, B, or C. So the Law Society suggests adding after the end of paragraph A the word or. So to make it A or B or C, meaning either one paragraph would be sufficient. So there are also further comments on this point as well. So according to our initial reply, we think the position is already very clear. Paragraph 18, non-consent cautions. Similarly, Section 73A3, A, B, or C. I will not repeat the position. Paragraph 19, inhibition orders. Inhibition orders are court orders to prohibit the disposal of the property. Now, the Law Society's position is that the sale of property by the lessee or the chargee should also be included. Now, in our position, unless otherwise provided in the inhibition order that the power of sale by the chargee, that is the mortgage sale, is prejudiced, we would not want to change the rules. Now, the Law Society say that we should also add sale of the property by the landowner into the provision as well. But we think that our major intent is to prohibit sales by the landlord. So we will reply to the submission in greater details in the future. Now, paragraph 20, ratification by court, section 82, brackets 5, in divisible title. Now, in our position, bona fide purchaser includes A, B, or C. For example, in the case of void or voidable instruments, A, B, or C, in the case of fraud, a case of mistake or omission, or void or voidable instruments, if the person fulfills either one of the conditions, they will not be granted the indivisible title. Now, in terms of the burden of proof, if the court is satisfied with any one or more of the events stated in paragraphs A, B, or C, then no order for ratification may be made against the registered owner who is in possession of the property and who has acquired the property for valuable consideration. Now, when a person applies for ratification under section 82, brackets 1, they need to satisfy the court that ratification order should be granted, that is, proving the occurrence of any of the events. So the burden of proof is on the applicant. There are no further views on this point. Finally, paragraph 21, the condition of impossession of the property concerning a ratification order. Now, for deferred possession, the Law Society is of the view that the vendor is not the licensee if they are still in possession of the property after the transaction. But in a position, they are still the licensee. We will submit case laws to explain our point. So we will further explain our points to the Law Society. Thank you, Mr. Lee, for explaining your positions clearly. As we have mentioned, on the 2nd of July 2025, the Law Society further submitted some questions to the administration. There's CB brackets 1138. I think the administration will reply to the submission further. Many questions were asked about the charging order. That is also very important, and I look forward to your detailed reply.
So, members, we've completed the clause-by-clause scrutiny of the Chinese version of the bill. My question is now for the legal advisor. In relation to drafting issues and the English version of the bill, have you identified anything you'd like to tell us? Thank you. I understand that the government indicated that some amendments will be proposed, and apart from those already identified, we've not found anything inconsistent between Chinese and English versions. Right, on the 23rd of June this year, the Secretariat issued a notice inviting members to consider whether to move amendments to the bill for consideration by the Bills Committee. At the expiry of the notice, the Secretariat has not received any proposed amendments, whereas the administration has proposed amendments. The details can be found in CB bracket 11144/2025 bracket 03, which is the draft committee stage amendments. I will invite the administration to walk us through the draft, and members, if you want to speak, please press the request to speak button now. Mr. Ambrose Lam and Mr. Louis Long will have questions about the CSAs. Is that right? No, Chairman. My question is whether there'll be another meeting after today. That depends on our progress. Right. I have a suggestion. If we have another meeting after today, and since we are quite concerned about Law Society's submission, we have had 2 rounds of exchanges. And I'm quite confused. There is a further submission from the Law Society. It's not a very long paper. So I wonder if the administration can prepare a paper to explain, put everything in context, and help us understand all the submissions and the responses. Yes, Mr. Louis Long, is it a question on the CSA or otherwise? Chair, you mentioned at the expiry of the notice, members have not proposed any amendments. Whilst this may be true, I'd like to reserve my position, because I'd like to read through the government CSAs today before deciding whether to move any amendment myself. So just to put this on record now. Right, let's hear from Mr. Lee about these CSAs first. So I will now give the floor to Mr. Lee to explain the CSAs. I'll give the floor to Ms. Wong. Thank you. About the committee stage amendments proposed by the government, there are different categories. I'll go through each of them. A. Amendment in relation to new land being exempted from the Land Title Ordinance Cap 585. Some stakeholders are of the view that the proposed amendment to Section 13A restricts the registration of disposition of straddling land, which will affect the integrated development of the adjoining lands, that's land in Cap 128. The government now proposes an amendment to allow the land registrar to allow applications after the amended Cap 585 has come into effect under specific circumstances, so that Cap 182 land for in situ exchange will be exempted from the scope of application of Cap 585. Upon approval of the application, this exempted piece of land will no longer be new land. It will be regulated under Cap 128, and developers can then take forward joint development with the adjoining Cap 128 land without being bound by Section 13A of the amended Cap 585. Mr. Louis Long. Well, I thank the administration for heeding our suggestions. The administration has taken on board the views of the sector in proposing this amendment. Still, I don't understand the following. According to this amendment, the adjoining land must be owned by the same owner. What is the policy intent of this requirement? According to the sector, they would like the government to adopt the facilitator mindset. This bill may affect the development potential of the adjoining land, and this must not be the policy or legislative intent of the bill, right? So the government has now proposed an amendment. But why is it that the ownership is still bound by the old requirement? That is, only if you have the same owner will you benefit from this amendment. In older districts, in the event of urban renewal, very often the adjoining land may not be owned by the same person or the same company. By imposing this restriction, two respective companies owning different pieces of adjoining land will not be able to take forward development in the form of a consortium. So consortium development is rather common in the sector. My suggestion is to do away with this ownership requirement as well, because since through this amendment you're carving out the adjoining land development requirement, you should also address the ownership of adjoining land. There should not be any restriction of the ownership being the same for adjoining land. Who will take this question, please? Now, if there is no requirement for the adjoining land to be owned by the same entity, then very easily this exemption can be granted. It can be subject to abuse. In other words, as long as you have a Cap 128 land adjoining yours, there is no need to have same title for the same owner for two pieces of land for the purpose of land exchange under Cap 128, and that will be opening the floodgate. The legislative intention is for the land to be owned by the same natural person or legal entity or even a group. I don't think Mr. Lee has answered my question. Of course, if the two pieces of land come under the same group, then the amendment has captured this scenario. I'm talking about two different groups respectively being the owner of the adjoining land. Now, Mr. Lee talks about abuse, and I'm perplexed. Why should anyone abuse the exemption? If there is development potential for two adjoining lots to be developed together, and that the outcome of this integrated or joint development will be better than respective developments on both lots, then naturally somebody will apply for this exemption. Otherwise, no one will apply for land exchange out of the blue just to apply for this exemption. There must be an opportunity for this lot to be developed. And certainly, this development opportunity will bring benefit to both owners for a joint development to take place. Now, the Bureau often emphasizes the facilitative mindset. So it's for the government to facilitate development and not to be inconsistent in the handling of this matter. It's not for the government to put in extra hurdle to hinder development. So that's my suggestion for the administration. Permanent Secretary, would you like to give a response? Because there should be an incentive. So if this is carved out in the amendment, what is the incentive for abuse to take place? P.S. Let me put it this way. We are putting in place a new title registration system. So unless there are strong grounds, we'd like all new land to follow the new title registration system. So that's the number one principle, unless there are cogent grounds for departing from the new system. Just now, Mr. Louis Long explained the position about adjoining lots. Under the current deeds registration system, one of the lots is registered under the LRO, whereas the other lot is regarded as new land under the LTO. Now, in the scenario of joint redevelopment of on the adjoining lots as mentioned, whilst we note from the discussion with Mr. Long and developers that such a scenario is unlikely to occur. And in fact, Mr. Long also admitted to that as well. We, however, continued to give it a thought. That is, in order to allow redevelopment to take place on adjoining lots, we should put in place some requirements, one of which is for the two lots to be owned by the same entity. And by entity, we're not suggesting actually the same, say, natural person. Like Mr. Lee explained, the lots could be owned by subsidiary companies belonging to the same parent company. We are concerned, however, if we further extend the exemption to adjoining lots owned by two entirely different owners. We have not required the owners to prove the need for redevelopment. The only threshold is for the two adjoining lots to be owned by the same entity. And if we further relax this criterion, we will be opening the gate too wide. After all, we do not require the two lots to show us the significance of redevelopment. And if the redevelopment proposal can be taken forward by two different owners, we are afraid of abuse, because the principle, after all, is that under the new title registration system for new land, unless there is a cogent reason, we should go by the new system for title registration. And if we open the gate here, that means there is a big gap, and that even under the new title registration system, some lots can be given exemption.
Any follow-up questions? I will make a brief reply to the Permanent Secretary's statement. As I have said, in terms of land developments in all the districts, there are usually consortiums engaging in development together. Now, there are not a lot of cases involving adjoining lands, but we should not rule out the possibility of land developers collaborating to develop adjoining lands. On whether we are making the threshold too low, I hope the administration has confidence in the land title ordinance. 20 years ago, when the ordinance was passed, the intention was good, that is, to streamline the entire land registration system. Now I think there is a consensus to implement the land titles ordinance through this amendment bill and apply it to new land first. Now, only except for very special circumstances, for example, for old deeds with a lease term of 999 years, after land exchange, the value of the land would be affected. Only for those cases should we exempt the landlords from the new regime. So my point is, the administration should have faith in the benefits of this policy, rather than worrying too much so as to limit the effectiveness of the new regime. There are very good commercial reasons to do that. Now, Mr. Louis Leung there must be some incentives when landlords choose to remain in the old system rather than migrating to the new one. So when there are these cases, we shouldn't regard these cases as abuse of the new system, but rather of cases requiring help. Mr. Andrew Lam, well, I was not privy to your discussion just now. So I agree with the chairman. We shouldn't approach it from the perspective of abuse. Now, the government has the power to grant exemption to applications. So it is not our intention today to discuss under what situations should the government exercise the power to grant exemption. Yes, the conditions have been set out clearly. So should we list out exclusively or exhaustively all the special conditions to warrant granting of exemption? I don't think that's the case. The consideration should be retaining sufficient flexibility for the government to exercise discretion in the future. Permanent Secretary. Yes, actually, the exemption conditions are very specific. So for adjoining lands, one plot of land was registered under the old system, and the other land was registered under the new system. So before the existence of the amendments bill, we would not allow any new land not to register under the new regime. Now, having listened to the views from the land developers, there may be development proposals for 2 pieces of adjoining land. So please give us some time to consider Mr. Louis Leung's suggestion. We would like to listen to Mr. Louis Leung's views further. Now, to redevelop 2 adjoining sites, usually a consortium would be formed. So if the consortium is the future owner of the 2 sites, that would sort out all the issues. Mr. Tony Jay. So I welcome the Permanent Secretary's reply. The scenario mentioned by Mr. Louis Leung is not common. However, since there is a new addition to the requirements of land title, I think we need to strike a balance between the old and new systems. Now, some point in the future, all land title would be registered under the new regime. It's just a matter of time and transitioning. So as Mr. Louis Leung has pointed out, this is a much more streamlined system, so we shouldn't be worrying too much about abuse. So I hope the administration would consider it further. The point is you must respond to the issues close to heart to the industry. So that is decided. Please discuss it further with the land developers and also Mr. Louis Leung. Thank you. Please continue. Ms. Wong. Thank you. Part B of our CSA is to empower the district courts to be able to handle cases in relation to the new system. Now, we propose to include district courts under the definition of courts so that they have jurisdiction under the amended Cap 585. Now, according to we will amend Section 93 of the ordinance to empower the rules committees of the district courts to establish the legal procedure and court rules in relation to the amended Cap 585, and also to give district courts jurisdiction to handle cases with an assessed stamp duty value of no less than $600,000, rather than the court of first instance. Now, the judiciary considers that with a larger jurisdiction to be exercised by the district court, it can handle more cases and lower the processing time and the cost. Part C, amendments in relation to transmission of registration. Now, the proposed new section 68B1 sets out that charges should not be registered as owner. Now we propose to delete Section 68B2, 3, 4, and 9. Now, according to Section 68B1, estate managers must transmit its registration. Trustee in bankruptcy should also register the transmission. Now, we also propose to delete Section 68B 5 and 6 to align the provisions. Part D, amendments in relation to limitations of legal procedures. Now, to align the wordings and enhance the provisions, we propose to amend Section 31(1) concerning the limitation to initiate legal procedures. Now, we will also refer the reference to the limitation or expiry dates in the English text to align the references. we will clearly specify that an application to rectify the title registration record is the rectification concerning a certain entry. And also we will replace the term obtain and make with the term registration in section 83.1. Now, omission. In response to the views of the Bills Committee, we will add a new provision under section 76 to explain that the omission mentioned in Part 11 does not include omission to submit application for registration. Now, Part F, if the court has made a no-fault order, then the relevant personnel do not have the right to apply for indemnity. Now, in the ratification process, if the court is not satisfied that the entry is caused by any mistakes or omission, and a ratification order is rejected, then that is a no-fault order, and then the relevant personnel have no right to file for indemnity under the new regime. Now, section 84(1), specified order in relation to an entry in relation to fraud or a mistake, then a ratification application must be made according to a court order. We are also amending the definition for erroneous entry. Now, if there is a no-fault order made by the court under section 82(1)(c), the entry is not an erroneous entry. We will also move amendments, textual amendments, to section 84(b)(1) and delete the reference to no-fault order under section 86(a)(1)(b). G. Amendments in relation to cost of ratification. Now we will add the reference of fraud to the title of section 86(b) to specify that the arrangements about cost reimbursement only applies to fraud cases. The reimbursements of cost mentioned in 86(b) only refers to cases in relation to fraud, so we will delete the provision concerning application for indemnity on erroneous entries under section 86(b)(1)(a), 2, and 2b. We will also amend 86(b)(1) and 2 to align the wordings with 84(1).
In relation to 86(b)(1) and (2) and their respective amendments, there will also be another amendment to 102(ZPD). The reference to 86(b) will be changed to 86(1)(b) in relation to the government's right to recover paid indemnity. In order to ensure this right is in place, especially in relation to section 88(2), the exercising of the subrogation will not affect the settlement between the claimant and the third party. It provides in this amendment that according to 88(2)(a), the right claim is not affected. In order to protect 82, the right in 88(2), that is about the rights to recover the paid indemnity, the amendment provides that the provision does not apply to 88(2). Next, about the right to lodge an appeal. As per the judiciary's suggestion, we propose to amend 91(1) of Cap 585 about the registrar's right to appeal. Now, if the decision involves administrative matters and not suitable for the court to intervene, a judicial avenue is still available, and only when the registrar's decision involves substantive rights or land issue will the right to lodge an appeal be exercised according to Section 91. Both the government and the judiciary are of the view that flexibility should be maintained in light of the future policy implementation and court's operation. Schedule 5 should be amended, and we therefore propose to add 103(3) for the Secretary for Development to publish by notice in the Gazette by way of negative vetting to amend the relevant schedule. Transitional clauses and other clauses can be maintained as published in the notice. Category J, the relevant notice. In relation to electronic submission of registration of instruments, we propose to amend 24(1)(a) and (b) under Cap 128. Any person who dishonestly destroys, removes, alters, defaces any instruments or images submitted electronically commits an offense. The other amendment is that under Section 26A(1)(a)(1) and 2, the copies of the instruments and images submitted electronically can be accepted in court as evidence as well. Category K, other textual errors and technical amendments. We propose to maintain consistency, and we are going to delete, unless otherwise specified in the interpretation clause in Cap 585 and Cap 128. The next one is a comment from Law Society. In light of the amendment proposed in relation to 41A2 to expressly provide that the legal charge and the relevant instrument are relevant here. 41A2 only applies to applications for registration for relevant instrument pending and not yet submitted. And there is a textual amendment in relation to 31(4). The repetitive character in Chinese law will be deleted. The rest are also textual amendments. The next one is about the printing error. The Chinese word 鐵回 will be deleted and be substituted with the words 刪除 to reflect the meaning of removal in the English text. The next one is a textual error in Section 102(1)(h). The repetitive Chinese character 的 will be deleted. Next, the Chinese version 23A2A and B will be amended to maintain consistency with the English version. There will also be textual amendments to the English version of Clause 66(1) of Cap 585. Next, textual amendment to the English version of 60A1. Next, amendments to the English version of 68A2 and 69(4) of the proposed amendment to Cap 585. Any other questions on the proposed amendments from the floor? No? I think apart from what Mr. Leung said, and that the administration should follow up on this issue, I think that basically the amendments have been examined. The administration has also responded to issues raised at the previous meeting, They've walked us through the proposed amendments as well as the Law Society's submission. The written response will be provided to members by circulation once it is ready. Depending on the content, members will decide whether to hold another meeting. Like Mr. Louis Long said, we need to reserve our position. Let's hear from the administration again and see whether their response can satisfy or satisfactory can fully address the concerns raised by members. Right? After the administration has confirmed the date of resumption of the second reading debate, the Secretariat will inform members of the details, including the date of resumption, date of report to the House Committee, and the deadline for moving amendments. Any other questions? If not, I thank members for attending today's meeting. This meeting has come to a close. I hope that the papers will be ready as soon as possible and that we can give a response to the governments as well. It's been 20 years and we're making a big step. Thank you.